This is stick bug right here. You're lucky he's missing. Nobody struggles in front of me. What you do? Is he in emergency? You talk to him? What? You get any phone numbers? We just came and stood there. See the guy that's small talk. About anything. So we're ready to talk about. I gotta do those. Yeah. There's one that's hard me though. Thank God. What's your dad? Didn't say that. He lives at home. Hey, you got a water too? Hey, can you have it? Good. I have some water. I got 30. Jim, you know where you're going, right? I just want to you get any food? They're huge. I wish I could stop this. They had so many extra boxes. I'm not right. Hey, 4 extra boxes. I was about to call you.
You're just having those like reactions to your I don't even have my phone. Breezy in my car. Thank you. I know.
Yeah, dude. And then we all get to
All right. Have a seat. Good morning to all of you, and my name is Judge William Marietti. I'm the Chief Judge at the Circuit Court for Muskegon County, and it's my honor and privilege today to provide you with some remarks here before we actually begin the oral arguments and the presentation of the case to our Supreme Court. I first of all want to thank Reeths-Puffer High School for hosting this event. This is a pretty prodigious task to undertake, and there's a lot of people to thank for this. I know I speak for the other judges of our Muskegon County Court, both in the probate court, the family court, the district court, and the circuit court, to tell you that we're honored to welcome our Supreme Court for the state of Michigan here today, and our fellow judges and the court staff in the 13 schools represented here today. So you should all be consider yourself very fortunate. You're in all good company today. And we certainly are encouraged and enthused by the participation of so many schools from our county in this event. Today is a momentous occasion for Muskegon County and for this court. This is the first opportunity we've had to host an event like this. And so this is something that will be long remembered by this court and hopefully by our audience and all of you students who are here today to participate in this. First of all, as I said, we want to give a major thanks to the Reeths-Puffer High School for hosting this event. And this location is just great. I mean, the facility is unmatched, and there's a reason why we're here. It's because it's probably the best place to host something like this, and we're certainly grateful for that. We're grateful for Reeths-Puffer agreeing to live stream this event so that others who are not here today can actually participate and have an opportunity to observe the oral arguments that are going to be presented. As you can imagine, an event like this involves a lot of input from many people. It affects the entire school here. We understand that. It affects the entire day here and the staff. And we want to thank you all very heartily and thank Principal Beckman for his involvement and willingness to accommodate all this disruption in his normal routine. I would also be remiss if I didn't thank publicly the judges of Muskegon County and my staff who went through the conference calls and the planning to put this matter together. There's so many details that have to be worked through. I'm just grateful for their dedication to making this event come about. I particularly want to thank Lynn Seats from the Supreme Court for her coordination of this event. She's got this down to a drill, and we all were able to follow her cues and make this thing come off. So we really appreciate it to her. And I also want to particularly thank Judge Hicks from our own Muskegon County Circuit Court, who was very instrumental in persuading the Supreme Court to come here today to provide you with this opportunity. So a special thanks to Judge Hicks. And so now, I think it's time for the justices from the Michigan Supreme Court to make their appearance. And so I'm going to ask that you join me in welcoming them. All right.
Hear ye, the Chief Justice and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give good attention. The court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good morning, everyone. We could overhear what you were saying, Chief Judge Marietti, and we appreciate the leadership that you've shown in terms of this community connection program, as well as the leadership that you show every day on Muskegon County courts. So thank you very much, Chief Judge Marietti. And good morning, and thank you all for joining this court for its first ever arguments in Muskegon. We're all delighted to be here, and we thank everyone for the hospitality that you've shown us. I'd like to begin by introducing the members of the Michigan Supreme Court, if I might do so. To my right is Justice Brian Zara. To my left is Justice Bridget McCormick, Justice David Viviano, Justice Richard Bernstein, Justice Kurt Wilder, and Justice Beth Clement. Before I call today's case, I'd like to take just a few moments to welcome more specifically our students, teachers, and administrators. There are an estimated 700 students participating in today's event, including those from the following schools: the Reeths-Puffer schools, Fruitport, Mona Shores, Montague, Muskegon, Muskegon Career Training Center, Muskegon Catholic, Muskegon Heights, North Muskegon, Oak Ridge, Orchard View, Western Michigan Christian, and Whitehall. Thank you also to the Muskegon Bar Association. Thank you again to Chief Judge Marietti and all the judges from here in Muskegon County. Thank you to our attorney mentors, and thank you to all other members of the community who've assisted and facilitated today's event. We truly appreciate all of your efforts. Without our local partners, this court could not have a successful community connections program. We are altogether dependent upon the local bench and bar for their support and cooperation, and Muskegon has stepped up with flying colors in this, our 23rd Community Connections program in all the furthest reaches of our great state. We're also grateful to your prosecutor, DJ Hilson, who is also the president of the Prosecuting Attorneys Association of Michigan, as well as to the Michigan State Police, the Muskegon County Sheriff's Department, and the Muskegon Township Police. Today's argument is also being live streamed so viewers can watch it anywhere in the world. And I'm sure there are many, many persons awaiting and watching in Budapest, to Shanghai, to Calcutta. So we welcome all of them. Several housekeeping items, if I might please. First, with the exception of the media and professional photographers, we ask that you please don't take photographs once oral arguments have begun. There will be opportunities for this during the reception. Second, if you've not already done so, would you please turn off your cell phones for the duration of the proceedings? It's just not fair to the attorneys who are going to be arguing today that they be interrupted by these devices in the course of their arguments. Following oral argument, we encourage you to please remain in the courtroom for a debriefing with the attorneys who will be arguing this morning's case, and that debriefing will be moderated by our Supreme Court General Counsel, Tom Clement. Let me very, very briefly explain how we've gotten to where we are in the process today. Each month, there are roughly 150 to 200 appeals that are brought to our court from throughout Michigan, including, of course, from Muskegon County and surrounding areas. In almost all of these cases, there's been a dispute or an alleged crime that has brought about a trial. Following that trial, one side in the dispute has, of course, prevailed, and the other party has appealed to our Court of Appeals, arguing that errors or mistakes were made at trial. Following the resolution of this appeal, there is still, of course, one side in the dispute that has prevailed, and the other party has one final opportunity within Michigan to appeal, and that is what you're hearing this morning. This is a criminal case pertaining to the constitutionality of a search and seizure under our Fourth Amendment to the Constitution. I emphasize in this regard just one point of civics, just one aspect of American constitutionalism, just one aspect of our separation of powers that I'd like to make clear. And that is, this is a court of law, and it is the obligation of this court, which each of the justices take seriously, to decide cases coming before us on the basis of what is required by the law, not on the basis of our own personal consciences or preferences. And if there's a single thing to understand about what you're witnessing this morning, it is that we are here to decide what we believe in our best judgment is the law of this case. And by the time of today's oral argument, each of the justices is familiar with the facts of the dispute. We're familiar with the parties' arguments and with the record of proceedings and with the legal issues, but we may still need something more from the parties, and that's why we've convened this argument. The questions that we asked during oral argument and the attorney's responses do assist us in reaching a final decision, and equally importantly, they can assist us in crafting a clear and accurate opinion setting out the law in Michigan, if that is what we decide to do. And if we do decide to do that, of course, as soon as it's possible, we will share that opinion with the students and the classes that are here today. So our goal as a court is to leave you better informed about the equal rule of law under our Constitution. Our hope is that as citizens of your community and your country, part of what's known as we the people, the first three words of our supreme law, you will remember and hopefully prosper by this experience. So thank you again for joining us today, and we'll now begin the arguments. The case we have is People versus Meade, and I would call the appellant. There will be 15 minutes of argument for each side.
Good morning, Justices of the Court. Chief Justice Michael Ferrone, appearing on behalf of defendant appellant Larry Meade. This court,
Hold the microphone to your closer, please.
This court and the United States Supreme Court have often instructed that reasonableness is the touchstone of any Fourth Amendment analysis. The law is well settled that any police search undertaken without judicial involvement, without a warrant, is per se unreasonable unless it falls within a well-delineated exception to the warrant requirement. We believe this case could affect many people beyond Mr. Meade. Who among us could not find ourselves in the place of Mr. Meade? He accepted a ride from someone. He entered the vehicle with a backpack. Who among us has not done that? Entered a ride, entered a vehicle, perhaps of a friend or an acquaintance, brought a backpack, attaché case, purse into the vehicle with us. In this instance, the police became involved merely because of a bad plate on the driver's car. None of us checked the plates on the car when we accepted a ride. The car was stopped. The police had tremendous power at that point to bring the people outside of the vehicle, begin questioning them, and essentially start a police investigation. Now, the prosecution might respond that none of us are going to find ourselves in the place of Mr. Meade because Mr. Meade had 4 grams of methamphetamine in his backpack. Hopefully, not too many people in the room will be found with carry methamphetamine. But the police did not know that when they stopped the car and when they focused on the backpack and really decided, out of curiosity, mere curiosity, that they were going to get into that backpack. The officer, Burker, in this case, candidly testified. He had no probable cause to believe any crime was occurring beyond the driving without a license on the part of the driver. He had no reasonable suspicion that there was a weapon in the car. He was very honest about that. So where does this bring us? We believe that this court's order, respectfully, in LaBelle was wrongly decided. It is an order. It wasn't an opinion. It would be my assumption that less time is going to be spent on an order than an opinion, but we just simply respectfully believe that the LaBelle opinion is incorrect in 3 significant respects, and that the Court of Appeals opinion in LaBelle was right on everything and should have been affirmed. An opinion written by Judge Sawyer and joined by Justice Wilder, then Judge Wilder on the Court of Appeals. We believe that this court should actually take the Meade opinion from the Court of Appeals. If you were to change the name of the defendant, it would read exactly as it should. How did the LaBelle opinion get things right and this court's order in LaBelle get things wrong? Well, first, probably the most significant, and this is actually why the Court of Appeals ruled against the appellant. If we look at the Court of Appeals opinion in this case, our position is it's a wonderful opinion. We agree with 90% of it. It's well written, thoughtful, but they concluded that because of the Raucus decision and because of LaBelle's interpretation of the United States Supreme Court decision in Raucus, they had to find that Mr. Meade had no standing. Well, if we look at the Raucus decision, it does not hold that there's no such, that passenger standing does not exist in the law. It's been interpreted over the years. It's not even a new case. It goes all the way back to the late 70s. It's been interpreted, misinterpreted, not simply by the Michigan Supreme Court, but by courts throughout the country to mean that we're not going to recognize passenger standing in the police search of a vehicle. And we know that it's kind of at first glance, it's kind of an outrageous, or maybe that's too strong a word, but outlandish claim for the defense to make in this case that all these years, different courts, many courts, have misinterpreted raucous. But fortunately, 2 weeks, sometimes the fate strikes, and 2 weeks before, I think it was about 2 weeks before we filed our brief in this matter, the United States Supreme Court issued a decision in a case called, and this is discussed in a brief, of United States v. Byrd. And in Byrd, which did not involve passenger standing, but the court nonetheless turned to raucous because the Attorney General in that case, not from Michigan, different state, had argued that raucous apparently denies passenger standing. In Byrd, there's probably an analogy to a passenger because the defendant in Byrd was it was a rental car and he wasn't on the lease. So presumably that's how it arose. And the United States Supreme Court writes, quote, there, in raucous, the court disclaimed any intent to hold that passengers cannot have an expectation of privacy in automobiles, but found that passengers there had not claimed any legitimate expectation of privacy in the area of the car, which were searched. And that's true. If we turn to raucous, the defendants told the court that the evidence they were trying to suppress, I believe it was a weapon, related evidence to a robbery, wasn't theirs, that they didn't know about it. The United States Supreme Court recently held that, look, you can't have a reasonable expectation of privacy in property that you are saying is not yours. In this case, Mr. Meade has from the beginning accepted that the backpack was his. When Officer Burkhardt approached the car, he sees Meade with his arms around the backpack. When Officer Burkhardt gets into the backpack, discovers the methamphetamine, Mr. Meade immediately announces, actually before the officer said it was methamphetamine, Mr. Meade announces it was methamphetamine. At his trial, which wasn't much of a trial, he told the jury that the backpack was his. And he argued, which you, under the law can argue, that the jury should rule his favor because of the bad search.
Mr. Ferrone, why shouldn't this court apply the good faith exception to the exclusionary rule in this case? Given that the trial court judge and 3 Court of Appeals judges believe that the search was lawful under LaBelle, why wouldn't a reasonable police officer also believe that the search was lawful under LaBelle, especially when the standard state Michigan police manual cites LaBelle favorably?
Well, that's a good argument. I understand. That's not an issue we were asked to brief, but I understand that is the argument of opposing counsel. And here's why. The LaBelle order, it's an order. The law, the applicable law is raucous, and this other cases we discussed in a brief, Jimeno, Rodriguez. And those are not new cases, in particular, Rodriguez v. Illinois and the principal case, which makes raucous. So, given that law set forth in raucous, given the law in Jimeno, which says that a consent to search a vehicle does not necessarily include every container within the vehicle, the officer could not have been acting in good faith. And I use the expression good faith in a legal meeting. I'm not accusing the officer of anything outrageous, lying, this sort of thing. Actually, he was very candid at the suppression hearing.
But just more technically, does that mean is your argument that LaBelle was not finding appellate precedent because of raucous and Jimeno and Rodriguez?
It's actually not very clear. We've always assumed that it was because this court has issued opinions which state that an order, if it sets forth its reasonings in some detail, is binding precedent. So we have not argued otherwise. We think that would have been a losing argument.
So then it's your argument that it wouldn't be reasonable for an officer to have relied on LaBelle given Supreme Court precedent? Is that correct?
Yeah, well, our position is it would not have been reasonable for the officer or the person who wrote the manual or the department to use this court's order in LaBelle and disregard longstanding precedent in Raucous, Rodriguez, and Jimeno. It's sometimes the law conflicts, but the person who wrote the manual would have known that even the Supreme Courts of every state have to follow the law of the Supreme Court of the United States. These aren't circuit court opinions, district court opinions. We're all required to follow them.
But isn't it possible that someone acting in good faith might think, all right, so the Michigan Supreme Court did something that no other court seems to have done, but in LaBelle, it decided to parse consent searches in cars differently than consent searches in other places. I mean, is that one fair reading of LaBelle that would make it binding precedent upon which an officer acting in good faith could rely?
Oh, well, I can't argue that under the LaBelle order, what the officer did would be a valid search. And that's why we're arguing the order is just wrong. However, there's a fact, there's other precedent out there which takes precedent over the LaBelle order. But also, let's consider what the officer did. He stops the car. He knows almost immediately as he approaches it that this backpack belongs to Mr. Mead. He ignores Mr. Mead. There's really nothing on the record indicating, he certainly never asked Mr. Mead if he can search the backpack. There's not much on the record of any interaction between the officer and Mead. He instead focuses on the driver. At that point, all he has is a bad plate. This isn't, I'm not sure if that's even a misdemeanor, right? Involved in many cases like that. I think it's just a civil infraction. He asks her to get out of the car, or is out of the car. Police have tremendous power at that point. No one's going to refuse to get out of the car. She exits the car, asks for permission. The searcher searches her, finds nothing. Same with me, finds nothing. He knew the backpack didn't belong to Miss Taylor, the driver, and yet all he had in his mind to justify the search of the backpack was her consent to search the car. And we know under Jimeno that's not necessarily sufficient. Jimeno's not in the case either. It was the law when the search occurred. And we know that the officer, from the audio camera video inside the car, his partner had fixed on that backpack and were determined to get inside it. We know from his own testimony, he had no reasonable cause to believe there's going to be any evidence of a crime inside that backpack. We know from his own testimony that he wasn't concerned about a weapon being in the backpack. Mr. Beat is 15 feet away. So, in some sense, where's the good faith? Even under LaBelle, where is the good faith here? He did everything possible to achieve his goal out of mere curiosity. That's all he had, was curiosity about the backpack. There were some admissions made that these people had maybe, quote unquote, used drugs in the past. We've studied the case law in our brief. Two things on that. Number one, he didn't, they had already decided, the police had already decided to get into that backpack before those conversations were made. I'm not focusing on that too much because I think it's most or all areas of the Fourth Amendment, we look at things objectively, not the subjective intent of the officer. But it is the fact that it's part of the picture that he was intent on getting into that backpack.
So it's your answer, though, that the good faith exception doesn't apply because the officer should have known that LaBelle does not apply under these circumstances?
Well, the individual who wrote the police manual should have known, yes. I wouldn't say necessarily the officer. I don't know that he has any legal training. Actually, I think most people throughout the country who are non-attorneys, most police officers would know that a United States Supreme Court decision takes precedence over an order from a Supreme Court.
While the Michigan Court of Appeals has to follow our orders, the person writing the manual does not?
Well, that wouldn't indicate, of course they have to follow your orders, but that was an order after all, in Mr. LaBelle's case. And it's, yes, but they're also required to follow the decisions of the United States Supreme Court. And we think here, basically the Court of Appeals sort of indicates this, there's not really any ambiguity here. Raucous does not do away with passenger standing. Jimeno is very clear. Simply because you have consent to search the car does not give the officer permission to search or necessarily give them permission to search
I see where you're going with this. You indicated we didn't ask for briefing on this. We didn't specifically ask for briefing on good faith exception, but the order that granted this argument asked whether there are any other grounds upon which the search may be justified or the evidence may be deemed admissible. Wouldn't it seem obvious that would include the good faith exception?
Yeah, I think that's a fair point. You know, and we do address the good faith exception in our reply brief. I can't deny that. I mean, probably when I first read the court's opinion, I did not consider we're going to argue a good faith argument. However, opposing counsel briefed it, I responded to it, and I totally agree with what you just said. Looking at the order.
Do we know enough from the record to make a determination on the good faith exception?
I actually think the record as it exists is clear. The officers testified. No belief in probable cause, no finding of probable cause that a crime occurred. No reasonable articulation with belief that a weapon was in the car. I actually think the existing record is sufficient to deny applying the good faith exception.
Counsel, you've several times argued in response to questions from Justice McCormick and Justice Zara that the search here breached the Constitution in several respects. Isn't the problem with that response that the good faith rule is never invoked, it's never triggered, unless there's been some constitutional breach, some constitutional violation? So, assuming there's been a constitutional violation, what's wrong with the idea that the officer nonetheless had good faith in what he did in his undertaking?
I do not disagree with that at all. You know, clearly, the fact if there was a constitutional violation, that is when the good faith exception is invoked and applied. I do not disagree with that. And pretty much that's my argument on the good faith exception. And I guess I go back to where I started out. This case, you know, the good faith exception is going to impact Mr. B. It will determine whether there's a retrial or not. But the issues here are far beyond the impact. Actually, could be far beyond Mr. B. So I would ask that the good faith exception not be applied. I don't believe it fits into the Supreme Court decisions. We could go through those. However, I agree that the fact of a constitutional violation does not mean that the prosecutor can't invoke the good faith exception. In fact, that's when it is invoked.
Mr. Ferrone, at the time of the stop here, LaBelle was the law in Michigan. And given that fact, that the law was that there's no standing passengers, why wouldn't the good faith exception apply when the officer had no reason to believe there was an objective reason for the passenger to object to his search?
Well, those are valid arguments. I agree with arguments with the questions and the implications of them. I think they're all reasonable. My position is that's true. LaBelle wasn't ordered, went into details, applied to Michigan. Court of Appeals had to follow it. That's always been my assumption from the beginning of the case, but all the way back to the circuit court. Court of Appeals had to follow this LaBelle order unless we could distinguish it somehow, which is a different topic. However, the only response I have is that in the background are United States Supreme Court decisions, Rockies, Jimeno, Rodriguez, which the officer also had followed.
Let me tease that out a little bit. Is there a different standard for police departments, state police, officers on the street in regard to how you would look at what's good faith?
No, not that I know of. I'm not aware of any cases that distinguishes that. And as far as I'm aware, the same would apply to whoever drafted the manual. I don't know of any changing standards.
So if the state police manual says one thing, is the officer charged with doing something different?
No, I'm not here to argue that this officer had any awareness of Rodriguez or Rockies.
The point is, how does an officer know that the manual might be different? Supreme Court precedent.
Yeah, that's a fair point. I am not focusing on the officer so much as the person who drafted the manual. I think that is where the good faith argument fails. I can't.
Does the record reflect whether the officer was aware of the manual?
I'm not aware of that. I can't state with certainty that he didn't. It's possible it came up, arose as a topic. I don't have any memory of that.
Does it matter, or should it matter to us whether the fact that there's Sixth Circuit precedent that would go in the opposite direction of our order? No?
Does that factor into the analysis?
It's persuasive authority. We're not required to follow. This court is not required to follow it or apply it.
That's true, but is law enforcement required to follow that authority?
Yes, whoever drafted that police manual was obligated to, which is the state police department, to follow the Supreme Court decisions. And in their case, yes, also they should take into account decisions from the Sixth Circuit. I can't cite a case in which it holds that the police are required, in the state of Michigan, state police or local police are required to follow Sixth Circuit precedent. But it does interpret Rackus and Rodriguez and Jimeno. Those are older cases, but they've been, courts have been applying them ever since. So I would answer yes, they should have been taken into account by whoever drafted the manual.
But that's different with respect to the officer. As far as the officer knows, the manual is correct.
Based on the record that exists, I can't argue that the officer had any reason to believe that the manual could not be relied on.
If the officer knew about it.
If you knew about it, correct.
Are there any further questions? Thank you, Mr. Furlong. Thank you very much. Mr. Schrodenboer.
May it please the court, Jerry Schrodenboer, Jackson County Assistant Prosecutor. Well, let's start with good faith. People versus Kroll, 1993, an opinion of this court flat out says our orders are binding. You don't get to just ignore them. Now, what do we have in this case? Defense counsel at the trial level said, yes, the bell applies. It controls. Circuit Court agreed. Court of Appeals twice agreed. But defendant is now basically saying, but the police have to have a higher analysis here, much higher, to take a look at this stuff to see it. They should have kind of known things that the judges themselves didn't notice, and defendant hasn't really even come up with this until the Supreme Court level. Now, the question about the Sixth Circuit precedent, about 2001, I was in an argument before this court, and I made a little suggestion that maybe Sixth Circuit decisions are binding on this court. That did not go over well at all. Sixth Circuit opinions are not binding. U.S. Supreme Court are. It's try to find the Michigan trial lawyers who are up on, no, the appellate lawyers who are up on Sixth Circuit case law. There aren't many. There aren't many judges that are up on. And we're supposed to have the defense lawyers. Now, it makes it rather easy. That's the end of it. Defendant, incidentally, his brief did not address this. His reply brief said, well, the only thing it said in that one paragraph is this was not ordered by the court. Well, it was. Anyways, there is another issue in here, which is very, very troubling. 90 years ago in People versus Miller, this court unanimously said, when you're looking at a search and seizure issue on appeal, you may not look at what's going on and what came out at the trial. However, when I take a look at this booklet here, and I look at the first paragraph, I see a lot of facts in it that came out exclusively at the trial. Exclusively. Now, what happened in this case was defendant filed a motion to suppress, and he based it exclusively on the preliminary examination transcript. He did not ask for an evidentiary hearing. I looked at it personally, and I thought, oh, I happen to have found the LaBelle case. And based on the preliminary examination transcript, as so many people.
I just have a question, and I understand where you're going, but I just want to understand from your argument, why couldn't the defendant just leave? After he's pulled over, what was requiring him to even stay there? Why couldn't he just leave?
Okay, I'm not 100% sure about that, but I'm pretty sure that when you're in the middle of a traffic stop, that the person may not leave. That is a question of officer safety. I'm not 100%. The officer definitely has the right to order him out of the car. Okay. We know that.
But this is a civil infraction. No one's being placed under arrest. It's not custodial. So what I'm trying to understand here is, why am I here? Why can't he just leave?
Once it was done, he could have left, but for his being arrested. Yeah, certainly.
But he's arrested because he left his backpack in the car, correct?
That is correct. He abandoned it under the bell. That is correct.
He abandoned the backpack.
Yeah.
What should he have done differently here? He's ordered to get out of the car, correct? And
Yes.
he's ordered to leave the back. I'm just a little confused. If you have a traffic stop and you're ordered to do something by the police, how is that I can be ordered to do something and at the same time it's abandoned? I'm a little confused. Where's my freedom of choice in this situation?
There is absolutely nothing in the record at any point whatsoever that he was ordered to leave the backpack in the car. There is nothing that says that at all. He could have kept the backpack with him, and then when asked,
What would have happened? What do you think would have happened if he had exited the vehicle with the backpack? What do you think is on his mind in terms of, if I'm going to exit the vehicle and keep a backpack with me during a traffic stop? What do you think he's thinking if he does that? What do you think's on his mind?
boy, that sure is speculative.
Sure, it's speculative, but with the current events of today, what do you think is a reasonable thing that he's thinking about?
Considering they're all white in this case, I'm not so sure that he's concerned about,
Wait, what?
you know,
I'm sorry, what did you just say?
the defendant is white, the police officer's white. They're all white, so we don't have a racial problem. If that's what you're talking about, the events that are occurring.
Well, that's not what I was talking
Okay.
about. I was just trying to understand, you're the one that made that into an issue. I guess my question to you after you made that into an issue is, isn't anyone in a situation when, you're pulled over by a police officer, it's a little bit of a high stress situation?
Of course.
Isn't anyone gonna be in a circumstance or situation where, what do you do when you get pulled over? You put your hands on the wheel, right? Is it usually a smart idea to exit your vehicle carrying an object? Is that safe for the police? Is that safe
Not
for the
necessarily
passenger?
right away. Okay, what do? I stop the car, I turn on the light, I get out my wallet, and I get out the proof of insurance and car registration. That's what I do. In this particular case, the defendant was holding it. He could have kept it in his hands at the time.
He could have kept the backpack in his hands?
As he left the car, yes, I don't see why not. The officer, there is no evidence that the officer told him to leave that. Instead, he left it, as in the facts of LaBelle, and whether LaBelle is correct or not, we still have good faith, because that is, or at least as of this moment, that is still the law in Michigan.
It sounds like you think it was incorrectly decided. Is that fair to say? Do you think
No.
LaBelle was incorrectly decided?
No,
You don't?
no, I do not.
So make sense of it for me, given Rodriguez and Jimeno, make sense of how it was correctly decided.
Okay, Jimeno deals with when the officer,
We
when,
don't have to deal with it, just tell me why LaBelle, I know the cases, just tell me why LaBelle makes sense given those Supreme Court precedents. which
because they
obviously-
don't have anything to do with this. They don't deal with a person setting it down, knowing that it's the car's going to be searched, and Jimeno specifically says you can search the packages in the car. He puts it down there. That's a matter of abandonment. As this court said, and there is someone on this right here who signed the order. And he was right.
Well, and there's someone else here who had a different opinion that was reversed and thought that Rodriguez applied. So
That's
your
correct.
argument kind of goes both ways. So I'm just trying to understand whether LaBelle was correctly decided. It sounds like you think it is because it's
Oh, yeah.
distinguishable from the other. So
Oh, yeah.
why do you think no other jurisdiction has gone this direction?
I'm unaware of any cases that have specifically said that is wrong. If you shepherdize it, you can't find anything that says that. And I'm unaware of any cases, certainly defendant has not come up with any cases that directly control under these facts. There is one case that is dead on point, and that's LaBelle. That's it. Yeah, when I found it, I was unbelievably shocked that I was able to find something so extraordinarily close. You normally don't find it that quickly. But basically, I have a three-part argument. The first part is, of course, good faith, assuming that you go outside it. The second part is, of course, the inventory search. And the third part is that LaBelle was correctly decided. Now, if in fact you look at the facts of the trial and you're concerned about those, let's not forget a few little details. The prosecutor had absolutely no incentive to develop search and seizure issue at trial, very simply because search and seizure is 100% irrelevant at trial. Number two, it's not entirely fair to the judge to reverse him based on facts that no party bothered to present to him at the time. And number three, if you start saying, let's take a look at the trial facts, guess what the prosecutors will start doing? They'll start sneaking these facts into the trial. Well, we're not entirely sure that the judge made the correct record. We have more record. When we start putting stuff in, and you bet that will be prejudicial against the defendant, so that makes it bad. And if you take a look at the preliminary examination transcript alone, which is what Miller says, everything is fine. If you have a problem with this stuff, I recommend that the court remand for a full evidentiary hearing, something the defendant has never requested.
Counsel, you keep saying that the defendant abandoned it by leaving it in the car, but what LaBelle held was that the driver consented to the search. Is that really what you mean? I'm just trying to understand if you're making a different argument than the one LaBelle stands for.
LaBelle stands for defendant left it in there knowing that the person had consented to searching the car.
Okay, so if I am
Yes.
pulled over I'm riding in an Uber and my Uber driver is pulled over and because his plate's expired, and have I consented to have the police search my purse?
No.
Why not? I get out of the car, they tell me to get out of the car. Have I
You
consented?
get out of the car, you take the purse with you, you show them your identification that you're a Supreme Court justice, and you will be gone. There will be no
I'm
problem.
not allowed to talk to a Supreme Court justice when I'm pulled over. That's unethical. My boss told me that.
Yeah, I remember Justice Taylor once giving a nice little article, story where he twice got pulled over on the same night, on the same stretch. And both times, I was the justice. The second time, the officer went up to him and said, Justice Taylor, what are we going to do with you?
That's when we had suppressed plates.
Uh,
I knew who he was.
That's how we do. Yeah.
Yeah, and there was just my plate too, suppressed.
All right, so you think I would get out with my purse
Yeah.
when the officer tells me to get out of the car? That's okay. And so you think the defendant here should have gotten out with his backpack, and by not getting out with his backpack, he understood that the driver's consent to search to the car extended to his personal bag.
That's right, and that's what it comes down to. Yes.
Isn't that what happened here? Did the driver get out with her purse?
Yeah, I think so. I'm not positive about that.
Did the officer ask to search the purse?
The officer has to search her, the male officer. Yeah, I know. And the reality is, it didn't matter that much to me because he didn't find anything. Did the officer have probable cause to believe before he searched the backpack that there was something in the backpack? I don't think so.
I thought she consented to the search of the purse as well.
If she did, she did.
So here we have the defendant in the back seat,
No, in the front seat.
or the front and the passenger side, trying to observe what's going on.
I would assume so.
So leaves the backpack in there so he can consent to a search knowing there's nothing on him.
Yeah.
I'm thinking, but that's my speculation. Let me get back to good faith
Okay.
for a moment. Opposing counsel said that the record is sufficiently developed and was briefed in reply to you. And that, as I pointed out, the court did ask for anything else that could be pertinent. You did raise good faith.
Yes.
Do you agree that the record is sufficiently developed? Does it matter? Do we know, first of all, do we know whether the police officer is aware of the manual?
That is not part of the record. If in fact you think that is not good enough, I would suggest remanding for an evidentiary.
Does it matter whether the police officer knew the manual?
On the other hand, I am completely unaware of any case that specifically says for good faith to apply, the officer must have actually known about this particular case. There are a lot of cases that came out after Arizona versus Gann came out in 2009 that none of them specifically said, oh yeah, we should ask if he actually knows about it. And it really comes down, let's not forget, it's an objective standard, not a subjective standard. People versus Arterberry, 1989, or is it 88, one or the other? Unanimous opinion written by Justice Charles Levin basically said, oh yeah, there was a proper search here. They had probable cause to arrest based on this. Yeah, probably not.
You might have answered my question, but I didn't quite grasp the answer.
Okay, I'm
Opposing
sorry.
counsel thinks the record is sufficient, and if we go to good faith exception, he wins on the law. Do you believe the record is sufficient? And if so, I take it you win on good faith exception.
Oh, yes. I
Is the
do.
record sufficient?
I think it is. However, that's of course not the real question. The question is, do you think it is? So if you think it is, fine, then it's affirmed.
Mr.
If-
Shepherd,
sure.
you didn't argue the good faith exception until your supplemental brief in this court.
Okay.
Why wasn't this something you argued to the courts below?
Because I happen to have a case called People versus LaBelle that was 100% absolutely dead on point. That's why. And it's not always a good thing to write a brief that happens to look like a treatise. Sometimes it's best to write on the short side. And it is, and I really, really doubt that
Those
this.
are two different things. So I think I take your first answer to be, I can't have abandoned it, given that there's no reason to call it into question. So I shouldn't have been expected to make that argument until I got to this court.
That's a possibility, but abandonment is a rather interesting point. I really doubt that the Supreme Court, that this court put in that third thing of, is there anything else? And then turn around and take it away from me and say, oh, by the way, it's abandoned, and we didn't really mean it.
I'm just asking what your argument is. I'm not asking
My
you to read
argument-
my mind.
My argument is,
We'll get to
Well,
that later.
oh yeah,
I just want to know what you think about
number
whether
one,
it matters. That's
number one, LaBelle is correctly decided. Number two, if you overrule it, there's good faith. Number three, it was a good inventory search anyway. Those are the three arguments.
How's it an inventory search?
I'm sorry.
How's it an inventory search? They searched before the arrest.
It doesn't matter. If you take a look at the Bailey case out of Pennsylvania that I cited, which specifically said they could have done an inventory search, that's good enough. It's an independent source, therefore affirmed. If you look at the facts in the trial, the officer specifically testified, one, I searched it as an inventory search. Two, there's a policy requiring to look at it as an inventory search. And three, it was impounded.
Since that time, it's never been raised in the Court of Appeals or elsewhere.
That is correct. And that's why when I took a good look at it once again, you see, once you granted them off, I had to reevaluate because I had always figured that LaBelle made it easy and that takes care of it, but I had to reevaluate. And when I saw that third line in there, the third question, I thought, okay, fine, I'll take a look at it. And there's no question that the car was properly stopped and neither person, and it's downtown Jackson, and neither person had a license to drive the car. There's absolutely no question
Cars
about
can
that.
be impounded.
Yes,
It's essentially, you say inventory search, it's inevitable discovery? Or?
yes.
And if I'm riding in Justice Czar's car and it gets impounded because he doesn't have a license, I have to leave my purse there?
No. Of course not.
Okay.
If you choose to leave the purse, guess what? It happens to
Oh, this is
get
actually-
searched.
You left it there.
But I would never consider it.
I wouldn't consent to it either.
I like to
Is that
just,
the lesson for today?
I just like to simplify things. I think the
Okay.
law kind of has to make sense.
That's a good
So,
thing.
oh yeah, so let's just go back to the early argument, right? I mean, the thing is that at the end of the day, when you're looking at these cases and we're looking at kind of what the policy implication of this would be, you know, we're concerned about the officer's safety, right? We're concerned
Yes.
about the safety of the officer. We're
Yes.
concerned about the safety of the occupants.
Yes.
So what you're saying is that if you get pulled over, you should just take everything out of the car with you. So if I get pulled over, do you think if we have some wonderful, wonderful officers here today, and if I was to ask them if they were doing a traffic stop, would they like the passenger of the car to take everything with them out of the car? Would they?
Keep in mind, I keep my CCW in my purse.
Yeah.
Is this what
Well,
they
the
want?
reality is, of course, if you're stopped and you have a CCW, you have a gun, You have to say it right away.
We're not,
Right
okay,
away.
that's a separate, we're not kind of,
Okay.
we're talking about the fact that we get stopped, right?
Yeah.
Is this what the officer wants me to do? Does he really want me to take all my things and stand and get out of the car with all of my things so he can't see my hands, he can't see what I'm doing? He wants me to take like a large item, like a backpack, out of the car with me. Otherwise, it's abandoned. Like, this is
The
what the
law
officers
does
want.
not require him to order him to keep it in. Now, looking at it from the defendant's perspective, he gets stopped. I strongly suggest that he not take the body out of the trunk. That would not be a good thing. No, I'm not suggesting that at all. He should take the stuff he thinks is good. The problem is, of course, if he happens to have a gun under the seat, the officer will see the gun the moment he's taking it under the seat, and then that, of course, creates probable cause.
This is a different case if the defendant says, may I take my backpack? And the officer said, no, leave it in the car.
Oh, yeah, we got a problem then.
Okay.
We got a problem then, definitely.
And just like you don't have to put your hands up in the air when you get stopped, you don't necessarily have to think, well, what's the officer going to want me to do, as Justice Bernstein is suggesting. You could have asked.
Yes. He could have asked. This guy has said that he has a very, very lengthy criminal record. So he knew the drill.
So he should have, I just want to understand what people are supposed to do. So when they get pulled over and the officer comes to the car, you have to ask the officer, your position would be that you have to ask the officer, may I take all these items with me out of the car?
No, I'm not saying that. In the first place, you sit in the car,
Right.
and if the officer never tells you to get out of the car, that's the end of it.
Right, but if he asks you to
If
exit the
he asks, it essentially orders you out, and he has the right to do that, order you out. You can take, a woman, it would shock me if the woman did not take her purse along.
Are you supposed to ask or are you supposed to just do it?
You're supposed to do it.
Okay, so your policy
You're
is
supposed to
you're
ask.
supposed to just take it with you out of the car.
Yeah, I rather doubt that he'll go into the trunk and take out the lug wrench.
But if the officer, if the person takes the item out of the car, the officer can certainly ask to search it
Absolutely.
for officer safety.
For whatever reason, the officer has the right to ask. Of course, the officer has no right to search it unless he has probable cause. And he has no right to do,
Or consent.
or consent, that's correct. Absent consent, he has no right to search absent probable cause. And he has no right to do the pat down unless he has a reasonable suspicion that the person is armed.
The officer's not gonna let the defendant or the passenger get out of the vehicle with a bag,
He's
holding
not.
a bag of material.
That's
If
not,
he's-
that's shouldn't be it. We're
That's-
supposed to get out of the bag.
My position,
If you're worried about officer safety, you have the right to do a pat down search for weapons. But you think the officer then, if he's concerned for his safety, wouldn't be concerned if the person has a bag or a purse or something within arm's reach where they could conceal a weapon? You don't think the officer should be concerned about that at all?
if we use that analysis all the way through, that would mean every last single traffic stop, the police officer has the right to do a pat down. And a lot of police actually think that, and that's not the law. You have the right to do a pat down only if you have a reasonable suspicion that the person is armed. If you have no reasonable suspicion that the person is armed, the police officer has no right to touch that backpack if the person leaves the car.
I'm not suggesting they have the right to touch the backpack. I'm asking you if the officer should allow someone to get out of the vehicle while he's investigating the driver and having a conversation and allow them to be near a bag that could conceal weapons. You think that's standard police practice?
Well, could consider in any situation. The answer is yes. If the court says that they are to do that, yes, they will. Because otherwise, it's a bad search. And of course, that leaves the officer open to 1983 liability. Yes.
Thank you very much, Counsel.
Thank
Are
you.
there any further questions? Are there any further questions of Mr. Ferraro?
Can I ask you just a question, just so you can clarify the record? Can you just help clarify this? What happened? That he basically did, explain to me your position to this? Did he just basically walk away and say, I abandoned this backpack in the vehicle so it could be searched?
No, he never left the scene. The officer asked him to get out of the car, he got out of the car. He left the backpack where he was sitting. And he never leaves the area. The record says he was 15 feet away from the police when the police started to search the backpack. I could elaborate on that more, but I actually think the questions I've heard indicate that you already understand my position is to expect people to grab objects under these circumstances is dangerous for the police and the citizen. This is a danger. And I also agree with you, Justice Bernstein, there's no racial aspect to this. We had a shooting in Eaton County some years ago. It was a white officer, white student, so this would apply to everyone. But also, the law puts the burden on the state to prove abandonment, consent, etc. It doesn't, and the law is very clear in stating, Florida v. Royer, we cite the brief, but even as recently in Birchville, North Dakota, that cooperation with the police at the scene is not equal consent to anything.
Thank you very much. Well, thank you again, everyone, for being here. We're very honored to have been here in Muskegon today, and we will look forward to speaking with as many students as we can and the members of the bench and the bar here in Muskegon at the reception to be held shortly. Thank you again. We stand adjourned.
Can everybody hear me? There we go. Good afternoon, everybody. My name is Tom Clement. I'm General Counsel to the Michigan Supreme Court. We're a little bit time limited, as the argument ran about 15 minutes long. But let's get started. Let's get right into it. Usually I give them a few minutes to kind of take a break. But since we only have 15 minutes, we'll get going. Before we get going, why don't we have a round of applause for our litigants? They both did a great job. So I do have, or I will have, or can have a few questions for the litigants, but I far, far prefer, especially that our students get engaged with this process. If there are things that you observed as you prepared for the case, as you read the questions, or as you read the facts and the briefs and whatever else you may have read, please come and ask those questions to me or to the litigants especially in regard to what transpired today, because it's a unique opportunity to see an oral argument before our state Supreme Court. Before the argument today, I had a conversation with Prosecutor Hilson, who said he had met with several students who were really engaged in this issue, really engaged in this case, and excited to see what this was all about. So people certainly don't want to hear from me. We want to hear from you in regard to what questions that you do have. So there are microphones. Where's John? John, where are our microphones at?
There's one upstairs, one downstairs.
Okay, great. So they're around here. So who has a microphone currently? Can you raise your hand? So right over here, and one up top over on the left there. So if you do have questions, please do feel free to come forward and ask whatever you like. Adults, certainly, you are welcome to as well. But like I said, we certainly would like to hear from the students. So as we get started, let me just start with this as you're coming up with your questions, and ask the litigants to introduce themselves, let us know where you're from, areas of law that you practice, and then just your general impressions of the arguments that we had today. Gentlemen?
We were talking,
Yes, you were. That's okay. Stressful 45 minutes. This is an easy one. If you could just introduce yourself to everybody, let us know kind of what areas of the law that you practice, and then most significantly, what your general impressions of the argument were.
Michael Fromm.
Does that work? I think that's not working.
Okay. Well, at this point, I am almost exclusively a practice criminal appeals. That wasn't always true. I've probably been involved in many areas of law, family law, some personal injury, employment law in the past, but presently criminal appeals. I forget the second half of the question was how I felt about the argument. I thought it went well. I liked the fact that the court was focused on the good faith exception. However, I mean, just that indicate that they agree with us on the main part of the case, which is whether the search is valid or not. However, I'm sure opposing counsel would agree with me. I've left courtrooms thinking I lost and they're winning. I've left courtrooms thinking it won and ended up losing. So you can't always tell from the argument how the court's going to go.
Yeah, I graduated back in 1981 and I went to the State Court of Appeals for a few years. From there, I went over to a federal district court, a law clerk for a few years. And then I hit the top of my prestige. I went to the Jackson prosecutor's office, where I have, yes, I've been, except for 4 years since, I am the appellate lawyer up there. In the meantime, I actually have argued a case at the United States Supreme Court. And I also do the extradition work for my office. I have received a national award for that. And I am now on a national board for that, the only county prosecutor in this country ever to be put on the national board for extradition, which is 100% completely irrelevant to what we're talking about here. How did it go? The Supreme Court, since '99, has used a rather different approach to oral arguments, making it a lot more difficult for people, for the lawyers who are in front. That did not show up today whatsoever. If this is the way that an argument should go, I am very happy with it. Which way do I think it will go? Well, let's see now. This is being recorded. And I have a funny feeling that whatever I say will make it back to the justices. So I think I'll just say the Supreme Court will do what it thinks is best. Which, believe it or not, is right.
All right, great. Question in the back. Thank you.
So, while I'm through the level, if the Michigan Supreme Court rules in favor and says that the officer had right to search the bag, then wouldn't that also go with saying that the woman should now be liable of the contents of the bag? If she has the right to give consent to the search, then why is she not liable of the contents?
Whom are you asking?
Either of you guys
Okay.
both look intelligent.
Okay, the prosecutor. Yeah, there isn't much. The thing is, we used up all our intelligence 10 minutes ago. I'm sure the defense counsel will agree with me 100% on this. There is absolutely no evidence in this case whatsoever that she knew that there were drugs in there. To be guilty of possessing drugs in this state, you have to have knowledge. Since there is no evidence of that whatsoever, and since the evidence quite strongly shows that it's his backpack, after all, he admitted it, and even at trial, he flat out admitted, yeah, I've got the drugs are mine. Yeah, which is why the jury took half an hour to convict. And yeah, there was never a question that the woman would be charged with anything because we did not have the evidence for it.
I would say I agree with that. In fact, I don't believe there's anything in the record indicating, so not very strongly, that she even knew the backpack was in the car. I mean, we might assume that because he had it in his lap, but it's late at night. I think there may have been some drinking. I don't know that she even knew the backpack was in the car, so there was no case against driving.
Yeah, there was no case. it didn't come out in the record, which is why I didn't say it. But this event occurred like 1:45, right downtown. Drinking, there's nothing in the record that says that. But the reality is, we would have had a horrible case against her. And in fact, we might have gotten in trouble if we had charged based on nothing.
Anybody else lined up? Yeah.
Okay, so I guess, it's loud. I guess my main question would be, I thought the law was pretty clearly stated that any contents within the car would be readily searchable, and the passenger, if they didn't want their bag searched, could have just said, that's my backpack, I'm not comfortable with you searching that. I'm just interested in how it got that far, or this far.
Well, actually, most of the argument today was focused on the good faith exception, so we really didn't talk about some of these other issues in a lot of detail. It's actually pretty simple. The police focused on this car for some reason. The plate on the car was bad, so they stopped it. And they asked the driver, can we search the car? She says yes. But they knew the backpack belonged to Mr. B. They testified, the one officer testified, said that the backpack belonged to Mr. B. So, it starts out as just a routine stop. There was nothing really unusual about it. But for whatever reason, maybe they knew Mr. Mead. I don't know what their thinking was. Maybe they were troubled by how closely he was holding the backpack. For whatever reason, they wanted to get into the backpack. But the stop itself, in search, how it began, wasn't really very unusual.
I'm curious to know what the bell is. You made frequent mention to it, the gray-haired man, and I am curious as to what it is.
Well, the bell is a case that was decided, I don't think it was that long. Yeah, 2000. Yeah, 2007, 2000, thereabouts, which is very similar to this case. The facts involved the defendant who had a backpack, police stopped the car, and maybe even stopped it for the same reason, the bed plate. The driver, consents to the search of the car. The officer testified that he knew the backpack belonged to Mr. LaBelle, I think it was Mr., it wasn't Mrs., to LaBelle, the defendant. So, very similar. When it was decided by the Court of Appeals, they ruled in favor of the defense, which doesn't happen as often as people think. And it was a beautiful opinion. They got everything right. And that reached the Michigan Supreme Court. And, that's just awkward, but the position of having to tell the court that they got the order wrong. And because they reversed the opinion by way of an order. They didn't grant leave. They didn't really do any full briefing on it. They reversed it simple order. So summarily, peremptorily. So that's the bill.
Well, actually, there are some differences, and I'm sure that the police and the lawyers will understand this. First difference, the one guy's name is LaBelle, and the other guy's name is Mead. In the second place, the backpack happened to contain, in LaBelle, it happened to contain only marijuana. In Mead, it happened to contain methamphetamine and marijuana. And the drivers were searched around. In LaBelle, it was a man driving the car and a woman in the passenger seat. And in Mead, it was a woman driving the car and a man driving. Yes, you lawyers know, of course, that those facts are thoroughly irrelevant.
Yeah, a legal word that we use, material. In other words, any difference doesn't matter.
To be fair, there is a background to this whole case that we didn't have any questions on, and that is that there was another difference, arguably, and that is that LaBelle had the backpack on the floor, and Mr. Mead had it on his lap. And so we had to decide whether there was a material difference or not. Well, the defense had already conceded, trial counsel had already conceded these two cases were alike, or the same. I think even my client did. I actually thought it was Mr. Mead who found LaBelle, but Who knows? It doesn't matter. But there was that difference, and that caused some. Eventually, my client lost some distinction. I had to decide: do I argue that the placement of the backpack is material? Does that, when I have these other good arguments, does that hurt my credibility? So there's that thing.
And yet, in the end, both times, when the officer searched the car, that backpack was on the floor, which is the point that I consider material. Actually, I don't even care too much exactly where the backpack was. If it was in the trunk, yeah, I'd have a problem, no question. But to me, I don't see any difference. Yeah. In the end, it was on the floor. And in my mind, putting it on the floor actually means more of an abandonment. But that's in my mind, and of course, the court will decide what it thinks is best.
Has the officer expressed his reasons for searching the car?
During the trial, he testified that he searched the back, he searched it pursuant to an inventory search. In other words, when a police officer impounds a car, they're allowed to go through everything in the car to make sure everything's there. If they don't do that, the person whose car it is will come back and say, but I had crown jewels in that car, and I want you to reimburse. And yes, that's what he said during the trial.
Just for the record, I don't believe the inventory search argument gets off the ground. But I mean, respectfully, Court of Appeals rejected it. It was a search for evidence. It wasn't an inventory search. That's our view. There was no testimony regarding the policies of the Jackson Police Department on inventory searches. Nothing. And it wasn't even claimed to be an inventory search until the trial, which we were supposed to consider. You know.
That's correct. The problem here is that search and seizure law is very complicated. And the lawyers themselves don't really understand it too well. And it kind of at times ends up as a bit of a mess. In addition to, notice how there were certain things that were said. Well, Michigan said this. What about these other courts? Well, we have this little thing called federalism. And if you take a good look at what federalism means when it comes to the law, not when it comes to reality, when it comes to the law, that means each state is its own country. The only thing that the state is bound by is the US Constitution. Okay, that transcends. But other than that, the state can do whatever it wants. And that's why cases from other places, like the Pennsylvania case I mentioned and Sixth Circuit, oh, they're persuasive. They're not binding. Supreme Court can just ignore it, can just reject it if it feels like it.
You have both referenced the good faith exception several times. Could you clarify what that means?
Okay, basically, if you tell the police officer, okay, let's start, go back a little bit. There's something called the exclusionary rule. If the police officer, let's say, as you're leaving here, police officer, for no reason or other whatsoever, grabs you, does a strip search, and finds marijuana. Yes, you are guilty of marijuana possession, unless you just somehow happen to have a card, which I really doubt. However, under those circumstances, we have something called the Fourth Amendment. We are to be free of illegal search and seizure, and I gave a fact pattern that is grossly illegal and that the police here would not do. We know that. And that means that if it is illegal, almost always the evidence gets suppressed. Well, if you're charged with possession of marijuana and the evidence is suppressed, well, guess what? There's no case. It goes out the window. However, good faith is, let's say that either a statute or case law flat out says that the officer may do something. If he then does it, later on overruling that precedent, well, wait a minute here. How does that stop the police from doing the wrong thing when the law said they could do it until years later? That's what good faith means in this situation. And as I said, search and seizure law is very complicated. And there's no question, I am not the top prosecutor in this state who does search and seizure law. And it would have been better for somebody else, Tim Puffer. But yes, the lawyers here know him. That would have been better, but whatever. I was the one they chose to stick pins into, so, okay.
No, just while you were talking, I was sitting here thinking the other court is going to hear, or potentially listen to our remarks. So just for the record, when I said we weren't supposed to consider the trial, I was being sarcastic. That was your position. You should consider the trial. So I just wanted to, just in case.
I have two questions. The first one would be, you said that they recognized that it was his backpack. So wouldn't that make it his property?
Yes, that's his
Yeah, he never disputed it was his backpack, and it was a very short trial.
Okay.
He didn't have a defense. I think he tried to argue to the jury to suppress the evidence for the backpack, and there was some back and forth with the judge, not allowed, and yeah, effectively. In fact, he might be here. He is done serving his time, and we told him about the hearings.
He was paroled last March.
And this coming March, he is eligible to be released from parole if he does well, which of course, both of us hope he does. It's not good for people not to do well on parole. We don't like people committing crimes. So I know she's had her hand up for quite a while.
I have two questions.
Do you feel like it would have been reasonable for Mr. Meade to have taken his backpack out to like come out of the car and say, I don't consent to searching this? Would that be a question of officer safety then and saying, okay, now I'm switching to that bag, hiding it? He said he searched it, they didn't. But if they left it in the car, they searched it and then
That raises an interesting question. The question is basically, if he had taken the backpack out and he had said, no, you may not look in here, does that give the officer the right to look in based now he is suspicious that there's something in there? Well, that raises an interesting question. In other words, you are invoking your constitutional rights. Does that give the officer the right to then just run roughshod over your constitutional rights? I don't think so. Under these facts, no. The officer has to have a reasonable suspicion, which isn't particularly much, but there's nothing in the record to that there is a weapon in the backpack. And no evidence came out on that, none. So, absent him having left it on the floor, this would be a bad search. And I hope that the Supreme Court isn't accepting having a transcript of this and then citing to this stuff.
Just our position, there was no abandonment. He did what anybody can do and should do. Under those circumstances, middle of the night, you don't want to have objects in your hand in the middle of the night doing back and forth with police. So I know Gerald disagrees with me on that, but just for common sense, I would tell people, police tell you to get out of the car, just get out of the car. Don't pick up anything.
It was said earlier that there is no evidence stating that the police officers told Meade to leave the bag in the car, so he could have easily just taken it out with him. So if you were the officer in the situation, what would you do if Meade had taken the backpack out with him?
I don't know that I would have done anything different. There is a case cited in LaBelle that talks about abandonment, But in that case, the defendant had drugs on him and he runs away from the police, he throws the drugs on the ground. That's abandonment, that's a classic abandonment exception to the warrant requirement. When you get out of the car and you leave your backpack behind, whether the police are there or not, you're not saying you don't own the backpack. So I don't see abandonment, we disagree on it.
Well, there's no question that that is the typical abandonment situation. The police are running after you, you have a gun in your hand, you toss it away as you're running. Oh yeah, that's abandonment. This is a little different situation, no question. The Supreme Court will make the decision it thinks is right. There are arguments that you can make both ways in this situation as to, is it legal abandonment? Is this good enough for legal abandonment? Is it not good enough for legal abandonment? The Supreme Court will make its decision, probably around June, maybe July. They have until July 31 to make the decision.
Just to follow up on an earlier answer from Gerald about the in general, the good faith exception, the exclusionary rule, there is an irony that is behind all in this case. I think the court, we all maybe see but haven't commented on, and that is the Rodriguez opinion that we've asked the court to apply to this set of facts. When it was published in 1978, that was a loss for the defense. In fact, it was over a dissent by three liberal judges on the court at the time, Brennan and Stevens and Marshall. So you can kind of see the direction the law's gone. That 20 years later, I'm trying to turn what really was a sword for the prosecutor that greatly expanded the consent exception, the warrant requirement, into a shield. Because at least Rodriguez requires the police to show something that holds up to some standards. And the LaBelle order, our position is, really doesn't. And ultimately, that's what the Fourth Amendment is about, the courts holding police to some standards.
Yes, that was a good time for me to go into the minutiae of the search and seizure issue in front of a crowd that happens to be a high school. So anyways, I think I'll hand it over. I actually have a question for Mr. Clement. Is it 100% coincidence that you happen to have the same name as the justice on the end back there? I don't actually know.
So we have time for one more question. One more question. Unfortunately, I'm sorry, I have to tell you that this is the most engaged audience that we've ever had, and I can't tell you how appreciative I am of that. And we want to answer your questions, so there is a reception after. You can come and talk to me, you can talk to the lawyers, you can talk to the justices. We're all available for you to have a conversation. So please bring your questions forward. I don't know who has the microphone now, but we'll do one more, and then move into wherever the reception is. I can't see that thing, so.
Okay, so you even admitted that it is irrelevant that they were a white male. And it doesn't really make any difference to it. But what was the point in saying it?
The point was, the justice made a comment about what are the things that are happening about things that are happening these days. And my mind switched over to the Black Lives Matters situation. And although legally it is not supposed to make the slightest bit of difference if the person is white or black, we all know that it just feels different. So when he said that, I thought he was talking about, and you know, when you read the transcript, you can't tell what the race is. It just so happened I looked him up, and I know that he is, he's white. So that was the comment, and then when he said that's not what he's talking about, I brushed it aside. Then my comment just went down the drain, so it doesn't matter anymore. And I can guarantee that the court's opinion will not address that.
Very good. Thank you, everybody. Let's again give them a round of applause. We can exit whatever way appropriate to the reception.
At this time, as I had mentioned earlier, we want to thank our guests from other schools. At this time, would you please make your way out of the Rocket Center, going the same doors as you did? Reeths-Puffer students, first lunch. First lunch students, you may go out the doors you came in. Second lunch, Reeths-Puffer students, you will be part of the reception. So stay where you're at. Thank you very much.
He's a good guy. I asked him that I had a good audio, great audio team. If he needed any sound bites, I'd be glad to give him some. And he shows me his little cube. He says, "Oh, I got it." Yep. Right. Mine takes forever. Excuse me, sir. Could you do me one favor? Yeah. See that cord right there where it comes out? Yeah, if you can pop it out, you got to pop on the top part. It has like a little, there you go. Push there. Thanks. Do you want rockets it is? All right.
Look at Jeremy.
Hey, Kate, come here. Where is she? Howdy, Mr. Manette.
You back here so all your comments were recorded the whole time?
Yeah, I was right under the camera.
I'm sure that all the technicians put a shield up its oh geez, we gotta let's follow the this one. Who's on second line? All of you? What a deal. Are your reception attendees?
Yeah, I know what that means.
Okay, those that are still in the Rocket Center, our dignitaries, our invited guests, and our second lunch Reeths-Puffer students. You're going to get an opportunity to meet and greet our state Supreme Court justices in Trophy Row, which is just outside the Rocket Center. For our dignitaries and VIPs, just outside the Rocket Center is what we call Trophy Row. That's the area that will have our state Supreme Court justices, and the luncheon will guide those that are going to the luncheon into our small gym where they are preparing to receive you near the 12 noon mark. So we've got about a half hour. So if you want to take your time, make your way out. You'll get pictures taken with our Supreme Court justices. And we've also have other dignitaries from Muskegon County that will also be happy to greet you.
You won't find out about anything until probably July.
Thanks again, Joe. I don't want to shut this down. It's still also doing something else. Pick it up.
This file? Yeah, here's the mic. Oh, no.